Okay, so this is being recorded, and my name is Mr. Max Chaudhary from Chaudhary Law Office. I'm an immigration lawyer with a few decades of experience, and the purpose of this webinar is to provide a forum to ask general questions, not necessarily legal advice, about Canadian immigration pathways and their related issues such as admissibility to Canada and some of those more complex kind of cases which do come up from time to time, such as in some cases complicated citizenship or delayed cases or things of that nature. So as I've indicated, this is being recorded. So if you don't want your details or your face to be anywhere, please keep the camera off. And by the same token, if you don't want your voice on social media, then similarly, communicate through the chat. So what I would propose is that people who are here, they pose their questions in the chat. I just want to adjust something here, right? Okay, and that way, if you are here, you can have your question responded to in as reasonable a way as possible, given the circumstances. So please, I will just make a note here, please send questions in chat. And then I already have questions for people who have sent in their queries ahead of time. And I want to just get to those in the event that there are no live questions in this chat, but as anybody who is here can pose their questions there. So to start, I just want to go through the questions, the initial one. Where is this here? So one second here. Let me see. Okay, so some of these questions are kind of general, but they may still be instructive for some people. As I said, the responses I'm making today will go on social media. So if you're here and want to pose a question, please feel free to stick it in the chat box, and I'll try to get to it and make a note of it. But in the meantime, one question is, what are the most common Canadian immigration concerns expressed by potential applicants? So this one is often really related to, firstly, determining the best pathway for Canadian permanent residency and a general relocation strategy. So in terms of general relocation, applicants frequently ask how they could relocate to Canada with their family or simply express their desire to live in Canada. And oftentimes graduates seek, especially graduates from Canadian institutions, are seeking the best possible pathway to gain permanent residency here. So those are sort of the general questions. I just want to see if I can take a look at the specifics here. Okay, so 1 second here. Okay, so this one is very specific. It is immigration options for people who are over the age of 40. So how to relocate with advanced education, such as a master's level of education with a family. So for this particular question, applicants, especially those holding advanced degrees such as a master's, if they have a master's in education and they may wish to move with their family, the best visa is really contextual. So when we look at specific programs, there is the ordinary express entry pathway. This relates to people with foreign work experience if we consider the express entry pathways subcategory of federal skilled worker. Federal skilled worker is simply the category that relates to people with foreign work experience. What's typically counted as work experience of within the past 10 years, up to a maximum of 3 years of work experience is typically given credit. Practically speaking, if you're over 40 years of age, then you would need a master's and ideally fluency in French. There have been some announcements, particularly the immigration numbers for Canada's immigration pathway for the year 2026, and they're maintaining that they will have allocations of spots for people who are speaking French. So if you're over 40, French is the way to go, preferably with a master's. So that's one of the specific questions. Another one relates to a temporary resident to permanent resident, so TR to PR. With respect to this TR to PR, this was a substantive path in 2021. That was during COVID, when you simply had to have a certain amount of education, and they lowered the points to 75 points, effectively. And you simply had to have a certain amount of education and presence in Canada. So technically speaking, if we think of that particular program, it does not really exist in its initial form in 2021. Rather, that there is a pathway made analogous to that, which is job offer based. So I'm thinking of programs related to encouraging people to settle in rural parts of Canada, such as in Thunder Bay. What has to happen, though, is those programs relate to individuals who have acquired a job offer. The job offer is essentially vetted by community members in that destination city. Typically, the business owners have input into what constitutes a valid job offer. So if you're fortunate enough to get a job offer that is certified under the rural pilot, then that would be roughly the analogous pathway from TR to PR. I mean, practically speaking, it's very different because TR to PR simply meant you were in Canada with Canadian education. The threshold of points was very, very low. So if you're thinking about TR to PR as it existed in the past, that will probably not happen again for many, many years. So if I just go to another set of questions here, let me see here. So then, so one question is, my postgraduate work permit was refused because my licensed immigration consultant, my RCIC, failed to upload my language score due to a clerical mistake. What can I do? So this is a serious concern involving a PGWP refusal stemming from what looks like a clerical mistake made by a licensed consultant. So applicants who face this situation are asking for what recourse or what help is available to them following the refusal due to this error. Dealing with refusals and appeals is a common worry. Applicants also express concern about how to appeal a denial of this kind of application. So in some cases, reconsideration is a possibility. Reconsideration is ideally best done if you have, if you're not adding new material here. In this case, reconsideration may not be suitable because they don't typically, a formal request for reconsideration doesn't normally include new initial material as opposed to the initially filed material. As a consequence, there may not be any other option except to reapply, but keep in mind that to reapply as a prospective PGWP job offer or job work permit holder, you have to have valid study permit status. And so in some cases, you may need to maintain the study permit status while or at the time of submitting the revised PGWP application. That could be the situation that might possibly lead to the reissuance of or the actual issuance of the post-graduation work permit despite not filing the appropriate material at the outset. And another question is, let me just look at the recent questions here. So I see a question here, which is, the question is as follows. My sister is on a study permit that's about to expire. She's working on a humanitarian application for PR. That would be submitted in a few weeks. And the person says that I understand that the agency application does not grant implied status, which is true. So the question is, what are the options that she has after her study permit expires? Can she apply for restoration of status or maybe a visitor visa? So this question will be posed increasingly more and more as the hundreds of thousands of people who don't have a pathway for PR may contemplate a humanitarian and compassionate application. But the question is thus germane, which is how to stay in Canada, because staying in Canada increases the chance of success for a humanitarian and compassionate application. So the short answer is that you want to at least have visitor visa status. So this, strictly speaking, would be a visitor record. In some cases, if you have the financial ability, you can study again, but that could be very, very expensive. The trick is that to express your intention as a prospective visitor record holder, you're basically saying you're going to be in Canada temporarily. This does not square with the intention you are expressing by filing a humanitarian and compassionate application. So as a consequence, the visitor record application used to extend your status in Canada could be a bit challenging, because you have to address the two different intentions. If you can successfully address the dual intention aspect of this, and that's in the regulations, so that means an officer does or is supposed to understand that if somebody is signaling they have a dual intention, and if the officer is satisfied that this person will leave in the event that their status expires, then they could still issue the visitor record extension despite the fact that you are expressing an intention to reside in Canada permanently. So that's essentially the way to approach that question. In terms of the other questions here, there's a very challenging one. Can someone obtain a skilled worker visa in Canada without having taken a French or English language test? So the necessity for language testing is a clear concern for those seeking economic-based immigration. So this applicant explicitly asked whether it's possible to obtain a skilled worker visa in Canada without having completed the required French or English language test, and if such a pathway exists, and how to proceed. So this is practically speaking not possible, especially now in this environment, because there were low skill pathways to work in Canada, and in some cases maybe even immigrate, where language was not essential. A lot of those have dissipated, so you really need a language test. And if you're considering express entry, it has to be as high as possible. There are categories such as entrepreneur, where the language test can be at the level of 4, if we think about the IELTS test. But that has to be supplemented with all of the normal documentation associated with an entrepreneur application, such as proof of funds, proof of provenance of funds, proof of a business plan, proof of sound business management, quite a lot of things. So Practically speaking, for most people, that is not going to be a viable pathway to immigrate or even work in Canada. So if we look at another question is, my family and I already have Canadian visit visas. Will this situation qualify us for a refugee claim in Canada? And what are key documents we should prepare before traveling? So because the person is not inside of Canada, we can't really advise about the merits of a refugee claim. This is distinct from overseas refugee applications, where there is a pathway. For example, if you have a sponsorship agreement holder providing the basis for the overseas refugee to immigrate to Canada, or similarly the group of 5 category, which is basically 5 people who set up a commercial entity to sponsor you to immigrate to Canada. But the way the immigration laws are structured, particularly around laws about human trafficking, we can't really advise with any kind of specificity about what you should do to be a refugee in Canada. On the other hand, if you're at the Canadian border or at a Canadian airport after visiting or using your visitor visa to enter Canada, we can give advice about that. And then another question, if I go to the next one, is, let me see here. The question, where is it here? These ones, let me just see here. Okay, bear with me for 1 second here. And oh yes, okay. So this person says they applied for immigration under the Ontario Provincial Nominee Program, but their application was deleted. It was a federal skilled trade oriented application. And then it was deleted. What can I do? Okay, so this is part of an announcement, I believe, yesterday. Today's the 15th of November. I believe it was the 14th of November. The government of Ontario indicated that they would cancel applications without reason, without any rationale. In this situation, because the law allows them to do that, there's really nothing you can do in this case. You can't go to court. I suppose you can ask for reconsideration, but there may not be any basis for reconsideration because you need to have a kind of legislative framework or humanitarian plea in some cases to ask for reconsideration. So there's simply nothing that could be done in that person's situation. This is kind of presaging Bill C-12, which is contemplating that the federal authorities have this ability to cancel applications. My reading of that is that this would relate more to temporary documents like visitor visas and study permits. But even still, the concept of simply terminating an application is not really in line with what we typically expect with due process and this kind of thing. So there's simply nothing that could be done in that situation. Right? Another question is, okay, let's see, how can a PGWP student extend her work permit to be able to apply for PR under the Ontario student stream in Canada? Okay, so to extend a PGWP, strictly speaking, what you would have to do is extend the work permit, but not under the auspices of a PGWP, because you cannot really extend a PGWP. You could get a different kind of work permit. That work permit would oftentimes have to be supported by a labor market impact assessment, unless perhaps you came from a country which allows for working holiday visas under the auspices of the International Experience Class category, Those are typically European countries where you can work if you have a job offer for a year. In some of these countries' categories, you don't even need a job offer. You can just come and get a work permit. But in this particular instance, it might be that a labor market impact assessment would be the way to extend the time to work in Canada. It mentioned Ontario Student Stream, so if there's a job offer in Ontario by an Ontario employer, maybe they could take up the role for doing a LMIA. I think a related question is, can a PGWP student with a full-time job extend their permit in June 2026? So it sounds like the same question. And all of this is extensions, so it might very well be labor market impact assessment. So just to follow up to the question about the OINP applicant whose skilled trade application for permanent residence was denied, the only possible method to deal with that would be maybe if there's a class action. That would be something along the lines of civil litigation at the Ontario court, but the merits of that would have to be explored, which I can't really get into here. Another question is, open work permit was refused while I was working in the health sector. Can I appeal for that? So the concept of appealing an open work permit, technically speaking, that wouldn't be a full appeal. It would be an application for leave to seek judicial review. So judicial review is distinct from an appeal because an appeal typically allows for further evidence to be given, and oftentimes the higher level tribunal or court that's in taking in that higher or that increased evidence actually makes a decision to grant a visa. But in this particular instance, a judicial review application means that if you have a work permit that got refused, you would have to submit there was a legal error or an error in due process, such as, for example, failing to consider some element of evidence that was filed. So one key distinction is that the cornerstone for a successful judicial review is that most of the time the evidence that would be there to grant the visa was already there. In other words, you cannot add new evidence to a judicial review in the vast majority of cases. So a merit assessment would mean that a lawyer, such as the lawyers here in our office, would review the negative decision, and we would review the documents that were filed in support of that work permit application. And then we would review any relevant laws and then determine if either the documents, the essential documents, were in fact there for that successful work permit application, or maybe there was a concern that the officer had which the work permit applicant could not reasonably be aware of. If that was the case, then it would be a denial of procedural fairness or a denial of due process, because if the officer has a pretty minute concern that isn't ordinarily arising from the law that you could not reasonably be aware of, that's how could you address that point? So in other words, you would have to have been given a procedural fairness letter before the refusal. If that was not the case, you were not given a procedural fairness letter, then that could be a denial of procedural fairness, and you could arguably be successful in a judicial review application for this. Okay, so this is the question, I'm exploring options under the Canadian Experience class. I have about 2 years remaining on my work permit, and I'm currently self-employed, but I'd like to build qualifying Canadian work experience during this period. So one thing to keep in mind is that with Canada Experience class, the essential elements are, well, you're working in Canada, obviously, but another key one is that you have to be in an employer-employee relationship. If you're self-employed, then the experience would not count. It could perhaps count under a different category, maybe the other subcategory of express entry, namely federal skilled worker. But even that would mean that you would have to make the case that you have a different point regime involved. Okay, this question is, I'm a Canadian citizen. My sister is not. She's age 55 with 2 kids, age 10 and 14. Both kids are studying in Canada and have a study permit for 4 years, and they've completed 2 years. So permanent residency for somebody of that age is generally not possible unless typically it's an entrepreneur application. There used to be a pathway related to getting a job offer with extra points, but in 2025, the extra points under express entry for either an executive level job offer or a non-executive level job offer, which had 200 versus 50 points respectively added to your profile, meant that you could overcome the age gap in that circumstance. The only other way would be if there's a provincial nominee program where you get a job offer and then you get the certificate of nomination. But aside from that, it's very difficult for somebody over the age of 55 or even over the age of 35, for that matter, to immigrate unless you're talking about business experience, for example. And then look at the other question is, I'm a Canadian citizen and recently got married. My wife is currently outside of Canada, and I'd like to apply for outland spousal sponsorship to bring her here as a permanent resident. What are the requirements? So for this kind of situation, somebody who is outside of Canada and married means that this could come under the family class because you have to be married or common law for that. And then the outside of Canada method of sponsorship is oftentimes shorter than the inside of Canada one. One thing to consider is that the outside of Canada sponsorship, if there's a denial, then the sponsor has a right of appeal at the Immigration Appeal Division of the Immigration and Refugee Board. And similarly, that's distinct from the inside of Canada method. The fundamentals of a spousal sponsorship include enough evidence to satisfy the officer that the marriage looks genuine. So what does a genuine marriage look like in writing? So that would mean that if there is an element of courtship, I'm thinking about as distinct from perhaps maybe arranged marriages where there is no courtship, then the development of that courtship has to be logical, preferably with some evidence. This could be chat records or photographs, maybe photographs with close friends and family. Eventually, there may be, depending on the nature of the relationship, there could be some evidence of commingling of responsibilities, sharing of responsibilities, this sort of thing. Obviously, if there's a baby or a child, that's a strong indicator of a genuine marriage. The idea is that, structurally speaking, there's an application to sponsor by the sponsor and the application for permanent residence by the applicant seeking the permanent residency. So there are 2 applications rolled into one, along with the government filing fee and this aforementioned documentary evidence, such as photographs, etc. So the ideal is that the documents are strong enough so that there is no longer a need for the officer to question the relationship, and it's genuine on the face of the written documents. On the other hand, if there's a concern about the genuineness of the marriage that is not assuaged by the documents, then the officer can convoke an interview. Then obviously you need interview preparation for that interview, which means you'd have to be familiar with what you said in the application, such as documents relating to the forms and the supporting documents, things of that nature. If the interview is successful, then everything is fine. If not, there is, as I indicated, an appeal at the Immigration Appeal Division of the Immigration and Refugee Board. So in terms of other questions here, general, I'd like to apply for a Canada visitor visa, and I have a valid UK and USA visitor visa now. So despite the fact that it's a generic inquiry, it's kind of a good sign for somebody seeking a Canadian visitor visa to have a valid visa to other developed countries like the United Kingdom and the United States. However, keep in mind that in some instances, there is some concern about where you are at the time of applying. So other factors include whether you are working, unless you're not working age. But if you're not working age, then how do you support yourself? Just to get rid of that concern about whether you're going to illegally work in Canada if you do enter Canada as a visitor. So those are some factors to keep in mind as well for this. But it's a good sign that you do have already an application for a visitor visa that was successful for the developed countries, right? Let me see, right? Okay, so another question is, this person said, I was denied post-graduation work permit because my full-time status was not presented. So this is a very contentious situation, because to be successful in a PGWP, you have to have valid full-time status as a student. It starts to get very unlikely if you have an absence of, let's say, 6 months or more as a student, because that means on the face of it, you're not a genuine student. This is barring certain circumstances, such as if you were not attending school due to circumstances beyond your control. And that would mean there's corroborating evidence, such as maybe medical evidence or things of that nature, which prevented you from completing your academic year as a full-time student. Other circumstances might be that perhaps the school didn't offer the right amount of courses at the right semester. In that situation, then maybe the school's administration made it not possible for you to be a full-time student, but there'd have to be corroborating evidence for that, to deal with that. If anybody's joining, this is the webinar for Chaudhary Law Office. Keep in mind that most of this will be ending up online, so you want to keep your identity, I assume you want to keep it confidential, and you want to keep your question confidential, so you could pose the question in the chat, and I can endeavor to at least give some direction to the response. The idea of this webinar is to express that, we do have paid consultations for substantive advice, but we're always concerned about people who are simply surfing the web about a question and are not really getting the right direction about how to deal with this issue. And we want to at least give people that right direction about any kind of question that they have, right? So in the meantime, I'll just go through the other questions that have been posted in advance, which I will again utter, and then this will end up on the socials, as the younger people say, right? So, and then let me see, the other question here is, okay, so this one is another post-graduation work permit holder question. So a PGWP holder applied for a TRV in 2024 and received the passport request, but missed 2 deadlines due to injury, and only mentioned the injury in the extension request, but provided no documentation, and the application was refused for failure to submit the passport. So one question is, what to do. Okay, so in this situation, if it was at least in the minimum before the refusal, you expressed the concern that you had some physical or mental health issue, and at least asserted it without evidence. In this situation, sometimes reconsideration can be contemplated for this, and perhaps providing the evidence showing that you could not submit the passport and or acquire the passport for submission due to this physical or mental disability temporarily. The only other option would be to, if you still have status, then apply for the TRV again for this. So with that in mind, I'll look at the other questions here. One is here. This is as follows. I am planning to visit last week of December 2025. However, my visit visa was rejected in 2019 and 2022, and I was sent back from the Rainbow Bridge. This is a mistake, and I thought this was part of the USA process and requested Border Police to let me go back, but he said he will send me through proper paperwork. Nationality is Pakistani. I don't want to get into any more details because I might reveal something about the person. So every time there's, keep in mind when you have a visitor visa and you attempt to enter the port of entry, such as the airport or the land border, they still have discretion to deny entry, which is what happened here. One question which is not clear here is whether the person was allowed to leave or was issued a rejection both times in 2019 and 2022. Related to this is that a rejection will be in the system as a rejection, and also this concept of being what's called allowed to leave means that you've effectively withdrawn your request to enter Canada. And there's no registration of a denial, but practically speaking, there is a denial. But it just looks slightly less difficult to deal with in the future. So one thing we always suggest is to, sometimes people retain us to get the government notes about their file to get the full picture and to confirm whether or not it's simply a misunderstanding as is asserted here, or was there a real lack of compliance under Section 16 of the Immigration and Refugee Protection Act, or even a misrepresentation. So something to keep in mind. So I just want to look at this question here. This says, again, a PGWP question. I applied for my PGWP in January with the help of a licensed consultant, sent them the required documents, but they made a clerical error and failed to upload the language score under the client information section, which resulted in a refusal after 8 months. Okay, what can be done now? So the key issue there is 8 months. So if the refusal was faster, and if the person still had study permit status, then maybe there'd be a chance, because you can only apply for a work permit within 180 days of graduating. Otherwise, it's no longer available to you. So in this instance, I guess you can lodge a complaint with the regulatory body for licensed consultants, use that complaint or evidence of that complaint to seek, I don't know if judicial review is worth it necessarily, because technically speaking, you did not comply. There could be a complex strategy where as soon as or soon after you get the refusal, you ask for reconsideration, and maybe at the same time file a temporary resident permit plus work permit application. Those things take a long time. They could take 6 months for that to happen. And the issue is that you don't really have status in Canada while you're doing that, unless you're restoring to visitor status. So if you want to cover all your bases, you want to have within 90 days, try to restore to visitor, then do a TRP plus work permit application, and include in that work permit application evidence that you've lodged a complaint with the requisite authorities about the consultant who failed to serve you properly. And then the officer could have discretion to grant the work permit based on the fact that, but for this mistake, an officer would have otherwise issued this post-graduation work permit. But really, there's not much else I could consider. In terms of which is the best option, you want to consult with a lawyer, you can consult with us. The consultation is a paid consultation. You can reach out to our clerk email, clerk@chaudharylaw.com for that. If there's any other question, please pose it. In the meantime, I'm just going to look at these questions that I have here. Because, as I said, these questions, the responses of which will end up on social media, would be forming the basis for social media content here. Okay, so it says, loss of status, urgent help needed. I lost my immigration status while my study has not been completed yet. So this implies that the person had study status on a study permit, and perhaps at the time for submitting an extension did not file the extension. In terms of the chance of success for regaining study permit status, it's much better if it's within 90 days. It's also much better if there isn't any gaps in studies. In other words, that you've been a full-time student. And it's also advantageous to have proof of acceptance from the school. These would be the essential ingredients for a study permit renewal and or restoration. Besides that, there's really the sort of overarching criterion, which is to show that you intend to be a genuine student and you intend to leave Canada if you no longer have status in Canada. So with that in mind, those are pretty well the questions I've received. So these will end up on social media. Thanks for reaching out, people who pose the questions, and perhaps, if need be, you can consult with us at Chaudhary Law Office here. You can go to the website www.chaudharylaw.com. That's CHAUD as in David, HARYLAW.com to reach out for a consultation related to Canadian immigration matters. And with that in mind, thank you so much. Bye.